Before we get started, please go over to Amazon.com and grab a copy of my book, Education and Justice. If you have an African-American son in public school, you need this book because I teach you the many ways that public schools mistreat African-American boys and what you can do to help your son. So go over there and get your copy immediately. All right, folks, I want to talk about something that's really near and dear to my heart. And that is, I want to talk about the National Football League, the NFL. I, like most Americans, we love the game of football, especially the NFL. A lot of us also love high school football, right? I played in junior high. I played as an elementary student. Okay, so I love this game. I love this game. And I love my team, the Pittsburgh Steelers. The Pittsburgh Steelers, the mighty Pittsburgh Steelers. Been a fan of the Pittsburgh Steelers now, about 50 years. So, yeah, I love the game. I love my team. I love the sport. But it is a very racist organization. Hey, family. Do you believe in the work we're doing? Does our content speak to you? Do you appreciate our in-depth legal analysis and political commentary from an African-American perspective? Do you believe it matters to our community? Then don't just watch from the sidelines. Please click that membership button and become a member of the 2% Club today. That's right, we need just 2% of our subscribers to become channel members. For just $4.99 a month, that's less than 20 cents a day, you'll help us keep creating powerful content that defends our democracy, demands justice, and develops a strong African-American community. But if you want more, at $9.99 a month, which is only 33 cents a day, you'll get access to exclusive members-only live streams, bonus content, and behind-the-scenes updates. And for just $14.99 a month, which is under 50 cents a day, our top-tier members get access to live Zoom calls, strategy sessions, and a direct voice in shaping this movement. We're not just building a YouTube channel. Folks, we're building a movement based on righteousness and justice, just what our community needs in a time of disinformation and division. So if you believe in what we're doing, click the membership button and join now. Become a member of the 2% Club today. Let's build something powerful together. And because of its racist history, a Coach Brian Flores, has sued the NFL. He filed his lawsuit actually back in 2022. And recently, he got a very, very favorable ruling. The case is not over, but he got a very favorable ruling. And I'm going to go over that ruling, and you need to stay to the end because this really could affect you and your job. The ruling in this case, believe it or not, could affect you and your job. All right? So let's kind of get into this a little bit here, talk about this game that we love, but again, it's an extremely racist league, the National Football League. No major owners or primary owners. I think there are African Americans who are part owners, like, for example, Magic Johnson of the Commanders. I think Condoleezza Rice, maybe, of the Broncos. I think there are a couple of African American part owners, minor owners of the Miami Dolphins. So there is some, but for a league that has like over 70% of its workforce are black men, especially, there should be more black coaches. There should be more black owners. And because this one brother, Brian Flores, believes that he was not treated fairly, he filed a lawsuit. And that lawsuit became a class action lawsuit. So Coach Flores is there in the middle. And joining his lawsuit are another couple of brothers, Steve Wilkes and Ray Horton. All right, so those three brothers have filed a lawsuit, a class action lawsuit against the NFL on behalf of other similarly situated folks who've been, in their opinion, mistreated by the National Football League. So hopefully some positive things are going to come from this lawsuit. And like I said, it could really impact you and your job. I'm going to show you something in just a moment that it was a very positive development, not only for these plaintiffs, but for everyone. So let's take a look at some of the language in the complaint, and then we're going to take a look at an order that the Second Circuit Court of Appeals handed down just about a couple of weeks ago. And that order concerns something that could impact you. All right, so let's go to another screen and read some of the lawsuit. Okay, so here we go. All right, so let's start at the top. United States District Court of Southern District of New York, Bryant Flores, Steve Wilkes, and Ray Horton as class representatives on behalf of themselves and others similarly situated. This is the amended complaint. They filed one and then they amended it. And I believe when they amended it, they added, Mr. Flores added Steve Wilkes and Ray Horton. Now look at the folks they're suing. So at the top of the list, the National Football League, okay? The National Football League. And just a second, I want you to see where I'm at here. Okay, National Football League. All right, hold on. Right here. Okay, National Football League, New York Football Giants, doing business as New York Giants, Miami Dolphins, doing business as Miami Dolphins, Denver Broncos Football Club, DBA Denver Broncos. These are all the teams that they're suing individually and collectively. The Houston Texans, Arizona Cardinals, the Tennessee Titans. They're suing all those teams and the rest of them. So they're suing the league and all of those teams. Some here they have named specifically because they have specific issues with those teams that they mentioned. Now, also notice that they came out the gate quoting Dr. Martin Luther King. And they quoted him saying, morals cannot be legislated, but behavior can be regulated. The law cannot make an employer love me, but it can keep him from refusing to hire me because of the color of my skin. So they took a quote from Dr. King and changed it around a little bit. Originally, it said, the law cannot make a person love me, but it can keep him from lynching me because of the color of my skin. So they changed it around a little bit. All right, now, so let's now read the bottom part of this. It says on February 1st, 2022, Coach Brian Flores, who is now joined by Coach Steve Wilkes and Coach Ray Horton, filed this class action lawsuit against the National Football League and its member teams. The suit alleged and continues to allege systemic racial discrimination in the hiring, retention, and termination of NFL coaches. All right, so they are alleging the NFL, as I've already said myself, the NFL is an extremely racist organization. And you may say, well, but how? The coaches are so nice and, you know, everybody likes Jerry Jones and this and that. I'm going to be teaching on the difference between individual racism and systemic racism. That's why they said systemic racial discrimination. There's a difference, big difference between whether someone is a nice person, but that someone is a part of a system that discriminates against a particular group, in this case, African-American men. All right, so it doesn't matter how nice Jerry Jones may be. Who cares? The issue is the organization itself and the teams are systemically racist, according to these plaintiffs. All right, it goes on to say, Mr. Flores, courage to step forward and speak out about this long-standing, undeniable issue, visible and obvious to everyone, was widely applauded by players, coaches, journalists, public figures, and the general population. And that would include me. I remember when he filed this suit, I was so happy that he did so. Okay? Not only are they racist in terms of how they treat potential coaches and players and so on, but they also showed extreme racism in how they treat retired players. They came to a settlement with players who has suffered CTE. You remember that, CTE? The brain damage that some players got from getting hit upside the head and falling and bumping their head so much. Well, the NFL tried not to pay some of those black players by something called race norming. And this is where they told doctors to deny claims by black retired players because black players, you can't really see where the CTE has affected their brains because they start out with less cognitive abilities than their white counterparts. Yes, believe it or not, that is the official stance of the NFL, that black men are less intelligent, have less cognitive abilities than whites in the league. That was their formal reason for denying black players funds from the lawsuit because of CTE. And we also remember how they dealt with Colin Kaepernick, who was standing up against racial discrimination in policing and police brutality and so on. So these folks are not lying, okay? Now, the NFL, that was 2022. The NFL has fought vigorously against this lawsuit. And that's why here recently, they finally got a favorable ruling that I will share with you in just a moment. A little bit more of this. In contrast to this outpouring of support, however, the NFL fell back on its tried and true playbook and reflexively within mere hours of the lawsuit being filed and without initiating any investigation whatsoever, issued a statement declaring the allegations were without merit. This class action lawsuit was and remains long overdue. The NFL, left to its own devices to police itself, has continually failed to address the massive imbalance and underrepresentation of black coaches and executives. The reality is that contrary to its contention that this lawsuit is without merit, even the NFL, in unguarded moments or in response to public pressure, has begrudgingly acknowledged the decades-long problem of systemic discrimination. The Rooney Rule. Now, that's something that my favorite team invented, the Pittsburgh Steelers. And basically, it was a rule where NFL teams are required to at least interview African-American applicants, coaches, at least. Weren't required to hire them, but at least to interview them. So this goes on to say the Rooney Rule, which among other terms requires NFL teams to interview minority candidates, was implemented in 2002 and is itself acknowledged. Hold on here. And is itself acknowledgement of the NFL's institutional failure to embrace racial diversity on its own. It's a good point. Because the fact that they need the Rooney Rule for blacks to even get an opportunity to interview tells you how systemically racist the organization was and still is. When the Rooney Rule went into effect, the NFL had only 3 black head coaches. Approximately 20 years later, when this lawsuit was filed, and after several amendments to purportedly strengthen the Rooney Rule, the NFL had only 1 black head coach, and that was Mike Tomlin, right? The Rooney Rule may have been well-intentioned, but it is not working. All right, so I'm not going to read any more of this. I want to go to the order, but again, I got to stress how racist this organization really, really, really is. And for some reason, we blacks, we give the NFL a pass. Now, when it came to Target, boycotting Target, we did that. When we've been called upon to come together on other things, we've done that. But our attitude seems to be when it comes to the NFL, all bets off. Seems like we just refuse to try to hold the NFL accountable for its obvious racism. Anytime you tell doctors to deny black players any sort of compensation from CTE claims because they start out with less cognitive abilities, and that was, and I guess still is, the position of the NFL, that is blatant textbook racism. Okay? All right, so let's go to what happened is basically the NFL fought Brian Flores and the other plaintiffs, and they did so by filing a motion. Now, here's where you come in. You need to hear me right here because this could affect your job. What the NFL did was it filed a motion asking the court to force the plaintiffs to arbitration. Okay? So, turns out, listen carefully, turns out in the employment contracts of these coaches, and I'm sure all the players, there is something called an arbitration agreement. Something called an arbitration agreement. And that arbitration agreement is where you have already agreed, if you have a dispute with the NFL, you have already agreed to go to arbitration rather than filing a lawsuit. So you waive away all kinds of rights by signing that arbitration agreement. We deal with this all the time in our cases. People not knowing that because they work for an organization, that organization has in their employment contract for everybody something called an arbitration agreement. So then something happens, you want to sue the company, and the company says, nope, you can't because you signed an arbitration agreement. And you're like, no, I didn't. No, I didn't. And they're like, yes, you did, and here it is. Then they pull it out and show it to you. I can't tell you how many times we have had to fight these arbitration agreements. So for the last several years, Brian Flores and the other plaintiffs have been fighting the NFL trying to get out of that arbitration agreement. And they won. They won. And that's why I'm telling you that that could be a victory for a whole lot of other people, not just the plaintiffs. Now, let me tell you why I say that. It's because when we're fighting arbitration agreements, it is really helpful to find other cases where judges have said, no, this person doesn't have to go to arbitration, doesn't have to stick with this arbitration agreement for this reason or that reason. And that gives us lawyers the opportunity to cite those cases as reasons why our client shouldn't have to be forced into arbitration as well. You see what I'm saying? So the fact that the Second Circuit Court of Appeals in New York said, no, they don't have to go to arbitration despite the clause, despite the agreement, that could be used in other employment type cases. And it's not just employment cases. They put these arbitration agreements in just about everything. You buy a car, there's likely an arbitration agreement in it. You buy a house, there's likely an arbitration agreement in it. You buy an appliance, there's likely an arbitration agreement in it. Okay, and typically courts will force you to abide by the terms of that arbitration agreement. Now, many times where you might be able to get out of the arbitration agreement is if you signed it and you didn't have an attorney there and you basically didn't know what you were signing. I'm sure some of you listening to me now may be in that exact situation now where you're trying to get out of an arbitration agreement that you signed. Because corporations don't want you to sue them and spend a lot of money. They'll spend a lot of money defending that lawsuit and so forth and so on, whereas an arbitration can be done pretty quickly, much less expensive, and the damages can be capped and the compensation can be controlled and all of that. So with them being able to get out of this arbitration agreement, it is good for the country. It is good for the country. Now, let's go back. Let me read here what arbitration is. It is a dispute resolution process. So arbitration, mediation, that is an alternative dispute resolution type of thing here. So a dispute resolution process in which the disputing parties choose one or more neutral third parties to make a final and binding decision resolving the dispute. Now, I take issue even with the way this definition is written up because it says the parties choose. Quite often, you didn't even know that you chose to do arbitration because you're not an attorney. And if you didn't have an attorney looking over the agreement, you don't even know you signed up for arbitration. So it's really not like you agreed to it or you chose it. You were blindsided. And by the way, if this happens to you, that is one of the arguments that you can make. You can argue that the contract that contains the arbitration agreement, or at least that term, the arbitration term, is unconscionable. You were taken advantage of. All right? So remember that. This could be good. This could be really good. All right, now, an arbitration agreement, therefore, is an agreement by which the parties consent to resolve one or more disputes by arbitration. So instead of filing a lawsuit, if you have an arbitration agreement in your employment contract or your car contract or your mortgage contract or your store appliance contract, under most circumstances, you're going to be forced to do arbitration and you will not be able to file a lawsuit. That's why I said you wanted to stick around here because this could be helpful to a whole lot of folks. All right? So now, let's go now and let's read the order where the judge said, no, they don't have to do arbitration. All right? Let me pull it up. Very important. All right, and here it is. In the United States Court of Appeals for the Second Circuit, this was argued on March 25th, 2025, and it was handed down, decided on August the 14th. And I assure you, Bryant Flores and those other plaintiffs were very happy to have gotten this ruling. And I'm happy for them because, again, it can be something that other people can use as well. But real quickly, let's read this. The National Football League, NFL, and 6 of its member clubs, jointly defendants, moved to compel arbitration of a putative class action brought by plaintiffs Bryant Flores, Stephen Wilkes, and Ray Horton, current and former NFL coaches, alleging in relevant part claims of racial discrimination under 42 U.S.C. Section 1981, it's a statute we use all the time to fight racial discrimination. The questions presented are whether the United States District Court for the Southern District. You see, it was the lower court who ruled that they didn't have to go to arbitration. And so then the NFL appealed to the Second Circuit. And the Second Circuit is essentially saying, we agree with the lower court that the arbitration agreement is not binding in this case. All right? And so this goes on to say more specifically, we consider whether the district court erred or made a mistake by denying arbitration of Flores' claim against the Denver Broncos and NFL based on its employment agreement. See there? That arbitration agreement is stuck in the language of Mr. Flores' employment agreement, just like it's probably in yours and every other agreement that you got. With the New England Patriots, which incorporated by reference the NFL Constitution, whether the district court correctly denied defendant's motion to compel arbitration of Flores' claims against the New York Giants, Houston Texans, and the NFL, and whether the district court abused its discretion by denying defendant's motion for reconsideration. What that means is when the district court denied the NFL and those teams their request or motion to go to arbitration, they then filed another motion asking for reconsideration. In other words, Judge, please, we ask you to reconsider your denial of our motion to go to arbitration. And the district judge denied their motion for reconsideration. So what did the Second Circuit do? Second Circuit said, we affirm the district court's order denying the motion to compel arbitration of Flores' claims against the Denver Broncos, New York Giants, Houston Texans, and NFL. We also affirm the district court's order denying reconsideration. So they said, district court, you did the right thing. We got you back. So now this matter is resolved unless the NFL and those teams file an appeal to the United States Supreme Court and the United States Supreme Court accept their appeal. If they don't file an appeal, or if SCOTUS does not accept their appeal, then this case will stay. They'll be able to go to court, pick a jury, put the evidence in front of that jury, and then that jury, not one arbitrator, but that jury, then can find the defendants guilty or liable or whatever their claims are, and award them some monetary compensation. So that's why I know these plaintiffs and their attorneys were very happy that the district judge indeed denied the NFL's motion to go to arbitration and those teams. Wow. I am celebrating with Mr. Flores because I have fought these arbitration agreements. They are hard. Courts don't like setting them aside. Courts don't like denying that motion to arbitrate. But sometimes it can happen. So what may happen here, I don't know. But since this arbitration agreement has been ruled unenforceable, they may now come to a settlement. I don't know. But if so, hopefully it will be a settlement that will address the systemic racism that the NFL has exercised against black potential head coaches, black executives, black owners, and so on. Okay? So just remember, we all love the game of football, but remember, this organization needs to be kicked in the rear end so that they can get their stuff together and start being fair in a game that, again, 70 to 80% of the players are African Americans. If we make up that percentage of the folks on the field, then by golly, we should be a larger representation of the coaches, the owners, the executives, and so on. Right? In other words, they need to start sharing all that money the NFL is making. You may say, well, but the players get well compensated. You know what? Okay, some of them do, and some of them don't. We just saw how they did Shedeur Sanders, right? We just saw that. One of the best quarterback recruits coming into the league this season. And look at what happened to him. Look at what happened to him. They were trying to teach him someone they considered to be an uppity Negro. They were trying to teach him a lesson. And it was just unfair. So again, we know this organization is racist. We looked at how they handled the Colin Kaepernick issue. I mean, that guy's career was basically destroyed because he took a stand against police brutality and racial discrimination generally in this country. And they destroyed his career. So these folks need to be kicked in the butt. I hope that they come out with something awesome and great from this lawsuit. As a matter of fact, I was so offended with some of the stuff that they were doing, I boycotted the NFL for about 5 years. I'm still not really looking at what's going on. I kind of keep up with it a little bit more, but I boycotted it because I know how racist this organization is. And as a civil rights lawyer, I can't get with that. I just can't get with that. All right? So, thank you for watching this video. I am Reverend and Civil Rights Attorney Augustus Corbett. And as always, remember, stay woke.